should have introduced myself earlier. Judge Marks had a hearing at 2, and she was the chief judge who introduced Judge Subel Cobb, Justice Cobb. And my name is Keith Watkins. I'm a senior judge here and have been here for about 14 years. So I first wanted to recognize my friend Reggie Walden, who's here in your class. Well, he's not in your class, he's an instructor. Reggie and I'm Watkins, he's Walton, so we sat together at a lot of conferences, and the judiciary puts us together alphabetically. And he's a senior district judge in the District of Columbia, and we've known each other for many years. So you've heard about Judge Frank Johnson when he was a trial judge here in this courtroom. He stayed in this building when he was appointed to the Fifth Circuit Court of Appeals. We have Judge Davina and Judge Carnes. Is Judge Carnes in here? He was here a moment ago. There's Judge Carnes, Chief Judge of the 11th Circuit, sits upstairs. Judge Davina, Senior Circuit Judge. And Judge Brasher, is Judge Brasher in here? I think he had hearings this afternoon. Is one of our district judges who will be joining the circuit court with Judge Tjoflat. So I want to introduce this next session. You heard from Judge Thompson. Now, Judge Thompson is a real judge. He was speaking to fifth graders. He didn't tell you this, but he was speaking to fifth graders this year, and a little boy came up and yanked on his jacket and said, "Hey, mister, are you a judge?" And he said, "Yes, sir, I'm a judge." He said, "Are you a real judge?" "Yeah, I'm a real judge." "What time's your show?" Judge Tjoflat was born in 1929 in Pittsburgh. I said 1929. This morning, he drove with his clerks from Jacksonville, Florida, which is a 6-hour drive, and this afternoon he will drive back to Jacksonville, Florida, with his law clerks over here, Jack and Megan. Yeah. He didn't have a state trooper escort. He probably didn't need one. Judge Tjoflat graduated from the University of Virginia, from Duke University School of Law in 1957. He practiced law for about 11 years and became a state court judge in 1968 in Florida. Then in 1970 was appointed to the Middle District of Florida by President Nixon. It took 6 days for him to be confirmed from the date that he was nominated. 6 days. He practiced there. He was a judge there for 5 years, and then in 1975 was picked to sit on the Fifth Circuit Court of Appeals, and that one took longer. That one took 17 days. And since 1975, he has served on the Fifth Circuit Court of Appeals, and then in 1980 or so took a seat on the new 11th Circuit Court of Appeals, and just took senior status 3 weeks ago, if I'm not mistaken. Is that about right? So Judge Tjoflat was very close to Judge Johnson, and Judge Johnson went on the Court of Appeals in 1980. His first law clerk was Debbie Long, who is going to enter into a conversation today. His first law clerk on the Court of Appeals in 1980. And Debbie Long is a graduate of Auburn University and a graduate of the University of Alabama School of Law in 1980. She clerked for Judge Johnson in that year, 1980-81, his first year on the Court of Appeals. Then she went to practice in Birmingham and helped start a new firm up there in the mid-'80s. And I don't have my glasses on. It's Maynard, Cooper & Gale is what it started out as. And in 1992, she became general counsel for Protective Life Insurance Company, a large insurance company in Birmingham, under the leadership of Drayton Neighbors at the time. And Debbie rose, she was on the board. She became an executive vice president and corporate secretary, as well as chief legal counsel for Protective, which at the time she retired last year had about $80 billion in assets. She is well known in all circles in Alabama for her charitable work. It includes Big Brothers Big Sisters of Greater Birmingham, the YMCA of Birmingham, the Oasis Women's Counseling Center, the Birmingham Museum of Art, Partners in Neighborhood Growth, She serves on the Alabama Women's Commission, Public Affairs Research Council, and she's been a director of the A+ Alabama Education Partnership, and director of the University of Alabama Law School Foundation. And proudly, we have set up the Frank M. Johnson Judicial Institute here at the court, and she serves as co-chair of that board as of this past year. So there's going to be a conversation here between Debbie Long and Judge Tjoflat. If you would welcome them, please.
Thank you, Judge Watkins. Ooh. Thank you for that introduction. I want to correct one thing. If you thought he was saying I was Judge Johnson's first law clerk, that wasn't correct. He had been on the bench 25 years when I clerked, but I was one of his first law clerks when he was elevated to the then Fifth Circuit. It is such a pleasure for the Frank Johnson Institute to be able to participate in this, and it's such an honor, Judge Tjoflat, for you to be with us. Y'all are in for a huge treat because Judge Tjoflat has the best stories and he's got the best storytelling manner, and so what we're going to do is tell some stories. But Judge, you were a district court judge when Frank Johnson was a district court judge, and then a colleague on the circuit after he was elevated. But also you were just dear friends.
Very close friends.
Yeah, and I know he thought the world of you. And I'd like to kind of set the stage because in many ways, the experiences you brought to the bench, the experiences Judge Johnson brought to the bench, they were very similar. And I think they probably informed how you approached the bench. Could you just talk about some of those similarities?
Well, he came to the Middle District of Alabama like a shot out of a cannon. President Eisenhower nominated him in 1955 with no idea he was going to be a federal judge. He was a U.S. attorney in Northern District of Alabama. And moving from the Northern District, an outsider from the great state of Winston, which seceded from Alabama during the Great War, he might not be too welcome down here. So at any rate, he hadn't been in office more than maybe a month or so when the Selma to Montgomery March occurred. So he was put right smack in the middle of things right away. I'm basically from the Midwest. Grew up in Pittsburgh, but in the summers I used to work on a little dairy farm my uncle had in Wisconsin. That's where you had Model T Fords, real Model Ts, and you milked cows by hand and pitched hay and all those kinds of things. And I was saying to Debbie the other day that there's not a lot of difference in the way people in the breadbasket Midwest, from western Pennsylvania up through Minnesota, say, and Iowa, the way they look at things, and people in the Deep South, they sort of have the same value systems. They have different accents, but aside from that, they have a lot in common. So I was practicing law in Jacksonville. I was the litigation partner in the largest firm in town of 28 lawyers in those days, doing all kinds of work, including some pro bono criminal work. In those days, the judge would just call you up and you defended somebody out of your own pocket. If you in the federal court, if you had to appeal a conviction to New Orleans, you had to pay the printer in New Orleans to print the brief, and flying to New Orleans was out of your own pocket and all those kinds of things. But at any rate, a judge on the state circuit court, which is like Superior Court, like Circuit Court here in Alabama, Superior Court in Georgia, general trial court jurisdiction, died one Friday. He had suffered what might have been a self-imposed pistol wound in his head. And we were having a Florida bar meeting, and Miami, and somebody walked in. We were having a party, a reception. Somebody said Judge Jones died today, and so there was under Florida law, the governor would nominate a replacement for the unexpired term of the judge. And I happened to be one of those freak Republicans, and we had the first Republican governor since Reconstruction, who, by the way, went to the University of Alabama Law School and was from Alabama. And so I was appointed, and boom, I hadn't been a state court judge more than a week or so. Then we had all kinds of turmoil in cases. Then in 1970, I was appointed to the District Court of Florida, Middle District. And Swan versus Charlotte-Mecklenburg Board of Public Instruction, which was the busing case, if you'll recall. All the school cases in the Fourth Circuit and the Fifth Circuit, and some in the Eighth, Arkansas, say, were being held on appeal, waiting for the Supreme Court to decide whether to provide a busing remedy, and the court did in April, and the remedy was all schools had to be desegregated, root and branch every school, and you could have a one-race school in a system if you couldn't desegregate it otherwise. And Jacksonville's school case was one of the 10 or 12 largest in the United States. The school district was 2/3 the size of Rhode Island, about 130,000 students, and boom, it was dumped in my lap. It was kind of like what happened to Frank Johnson. As a matter of fact, I was acquainted with Frank Johnson, and I called him up and said, I've got some business like you have. And as it turned out, all his federal marshals came to Jacksonville and provided us for protection. But at any rate, so we had a lot in common while we were both on the district court, because we visited each other at judicial conferences and all those sorts of things. And then I went on the Court of Appeals in 1975, so I'm grading his papers, as it were, until he came on the court in the end of the decade. And I think we both agreed on how judging ought to be. And I'll kind of put it this way, not say Judge Thompson did a magnificent job of portraying the human side of Judge Johnson, how he treated people, young lawyers in particular. What I'm going to kind of focus on is how he went about judging in these highly volatile cases. The first thing about Frank Johnson is that he was very well schooled in constitutional law. There's no question about that. Most of his cases were equal protection cases, white versus black, so that was easy in terms of the classes. He had an abiding faith, and I have too, in the American people's ability to sense the difference between right and wrong. Now, a lot of times those people are silent because the rabble-rousers on both ends of the spectrum get all the press and everything else. But at heart, he was of the opinion, and I was too, and other judges were, that if you handled these very difficult cases very deliberately, with an eye to the proposition that the press is going to report to the population what you're doing, because all these cases were of public interest. They were school desegregation cases, they were prison cases, they were voting rights cases, and they're being reported to the man in the street through the press. So the way in which you decide those cases, you write your opinion, you write it in a very deliberate, down-to-earth way so that the man or woman in the street can understand exactly why you're doing what you're doing. That's one point. Another point which is absolutely indispensable in those kinds of cases is that you bend over backwards to have a fair hearing. You got to hear everybody out, and you got to hear them in a courtroom like this, with the balcony full and everything else. If it's a school desegregation case, the school board's got the obligation to run a school system in a non-discriminatory way, and so you order them to come up with a plan, and then of course you have a hearing and everybody else has plans, and you have to hear them all out. And then you reach a decision. Then goes to the drawing of the judgment. But nobody can say they weren't heard, because in these cases, he never issued an opinion. I've read all of them. He never issued an opinion, a judgment, that was not right down to earth. He had a term. He said, "Put it down where the goats could get it." I tell my law clerks the same thing, put it down where the goats could get it. In other words, write it so everybody can understand what's going on. So if you can eliminate all the process issues, I call them side issues. I wasn't heard, or this person wasn't heard. So if you have those kinds, if you don't hear everybody, then it doesn't matter if the decision is perfect. Doesn't matter. Everybody wasn't heard. And I'm emphasizing now, everybody needs to be heard in all cases, but I'm talking about cases of great public importance. Everybody has to be heard. So you eliminate the side issue, I wasn't heard, and the public now has got to focus on whether the decision is right or not. Does it make sense under the Constitution? And so that's how he went about every one of these constitutional cases. There were exhaustive hearings, scores of witnesses, scores of documents, thousands of pages sometimes. And after he heard everybody, then he took everything into account and wrote a decision that was going to be in the newspaper, that anybody who could read and understand could see it. And so the idea was, while there was a lot of reaction, and I experienced the same thing, some people don't like what the decision is, but nobody could ever say they weren't heard, and nobody could ever say that the decision wasn't well reasoned out. So he was of the classical mode of constitutional adjudication. Now, what's that mean? That means to avoid the constitutional question if at all possible, decide the case on state law or a statute. If you have to decide it on a constitutional basis, you're well-founded and you write it as narrowly as possible. Now, in all of these cases, what is the court doing? It's issuing injunctions. Now, Rule 65 of the Federal Rules of Civil Procedure, and all state codes say the same thing, an injunction has to be narrowly tailored. And the remedy is as narrow as possible. And why is that? It's because the judge has got to be able to enforce the injunction. So when he had a school board in a case before him, he realized the school board, you've got to run the school system. And I'm going to give you an opportunity to desegregate the schools. Here's what you have to do, but you're going to do it. And so he would not hang over the litigants, the same way when he had voting rights cases and the defendants were registrars, voting registrars, who were systematically excluding blacks through all kinds of mechanisms. He said, no, you can't do that. You have to, here's what the law requires, and you're going to do it. That's what the orders would read. In the background, the people who were enjoined knew damn well that if they were in contempt of court, which happened sometimes, he would have a hearing and he'd hear them all out. And you'd have to explain why you did not do what the law required. So there were very few, if any, I can't recall any cases in which you put somebody in jail for violating an injunction and then gave them a key to the jail. You know how that is. You do this, that, the other thing, you'll get out. I don't recall any of them. One of George Wallace was having a picnic with Frank Johnson. They were in the same law school class. And he got one of these voting registration cases. And it was Macon County. It was Tuskegee, as a matter of fact, where Myron Thompson just told you about it, where they changed the city boundaries to put all the blacks outside the city and only whites inside. It used to be a square city, and then it had 28 sides or some such thing. It was just like a jigsaw puzzle. And George Wallace, of course, had to raise hell about Judge Johnson's orders. You know how that went. And the fact of the matter is, George Wallace, who by the way, was a circuit judge and was made a defendant in some of these cases, went to see him and wanted to know, are you going to put me in jail for criminal contempt because I'm rattling my mouth off? And George Wallace, I'll behave. And so that's how he handled these things. So it just textbook. How he went about his business was just pure textbook. Fair hearing, eliminate the issue that I didn't have a hearing, apply the law square out there, write the decision so that the man in the street or the woman in the street can understand it. And if the school case can explain to their children, here's why you're now going to this other school and not the neighborhood school. And then, of course, the media could not criticize the way in which he went about doing it. Couldn't possibly. So my thought is that a lot of people in Alabama knew that what he was doing in these cases, the decision he was making, and it was only one judge here in the Middle District, so he got all of the cases. And so that's the way he did it. I'm going to chat about the... You want to ask me something?
Sure. Yes,
I could talk all day about Frank Johnson.
I'd love to ask you something. You mentioned the orders in the newspaper.
Yeah.
I think it's important to point out that those orders were printed in the Montgomery Advertiser the day they were published, as soon as the new paper came out. So those orders were available to everyone. And I think you did the same thing in Jacksonville when you were desegregating
I had that
schools.
huge desegregation case, and the press published the opinion verbatim, including on a separate section where kids were going to go to school, because the school districts were all rearranged.
And in one of those with Judge Johnson, Judge Tjoflat mentioned that George Wallace went back and forth with rhetoric. So Judge Johnson would order something, and George Wallace would say, I'm not going to do it, and then he would do it surreptitiously. So he wasn't really in contempt, he just appeared to be.
Yeah.
And one of those newspapers read, I have it here, but it basically said, Johnson holds contempt was pretended. I mean, so people could actually see what was going on. It was fascinating that, we think in the internet we get a lot of information, but you got more information, true information back then.
No question about it. Everybody was reading from the same page, as it were.
And reading the actual decision.
Yeah, one of the cases in which the care that I'm talking about he took was the Selma to Montgomery march. On the 7th, it was a Sunday, on the 7th of March, 1955, 6, he'd been a judge 3 months maybe. The march started, and there was a bridge, and then went over a bridge, and the sheriff and the highway patrol and all kinds of law enforcement people stopped them, and there was violence. Now there were this was in the Black Belt. There were 4 counties. There was Dallas County, that's Selma, Wilcox County, Hale County, and I can't remember the other one, in which blacks outnumbered in population, voting age population, outnumbered whites. But from 0, in one of the counties, 0 blacks were registered to 7% of that population. And so they were demonstrating in each of these counties and meeting up with all kinds of cattle prodders and what we'd call stun guns, I guess today. It was bad. It was a bad scene. So the plaintiffs filed suit. That was on Sunday. A couple of days later, in Montgomery, seeking an injunction that would protect them to march from Selma to Montgomery. In the United States government, the Department of Justice intervened. And the plaintiffs, Dr. King and the rest, they wanted him to issue that injunction right now. He did the opposite. He issued an injunction and told them, you stay home. You stay home until we've had a full hearing. And so it was after they had days of a full hearing, and a plan for the march was laid out, in which people would be walking, no sidewalks. They'd be the 4 lanes most of the time. They'd be walking on the edge of the highway, where the Alabama law, a statute said that's where pedestrians would walk on that kind of a situation. So it was after a full-blown hearing. He stopped everything until that was over, and then he drew the plan. And the federal government had the National Guard standing by in case George Wallace didn't mobilize the Alabama National Guard. And so the march was done in a peaceful way, all the way to Montgomery. But you see, it was the way in which the case was handled. Who in the world could quarrel if he tells the plaintiffs, you stand still, you're not getting any relief, till we hear everybody out? And then you hear everybody out, and then you draw the remedy. So, right. And Judge Reeves, and then when the same thing with the busing case, involving after Rosa Parks, when they had the bus boycott that ran from December 1955 to 56, boycotted the whole bus line, and he and Judge Reeves and the judge from the Northern District of
Judge Lynn. Lynn.
Yeah, Siebert Lynn heard that case. Judge Reeves wrote the opinion. Judge Johnson concurred in the opinion. The other judge dissented, and the argument was whether or not the Brown versus Board of Education, the school case, had done away with Plessy versus Ferguson. That was the equal opportunity case. You know what that old case from the 1800s. And they said no. Brown and some other cases showed the way that the Equal Protection Clause of the 14th Amendment applied to the municipal busing system. But anyway.
So Judge Tjoflat, on that case, and Judge Thompson talked about this, you know, Plessy versus Ferguson was on point in terms of the actual facts, but the law had changed, and there were signals that were being sent by the Supreme Court. And sometimes district and even circuit courts have to read signals to figure out where the law is and where it's going. So can you talk a bit about that?
Well, let's just start with the Equal Protection Clause. The Equal Protection Clause said, in effect, that the city of Montgomery could not discriminate against citizens on account of their race. That's a given. That's what the clause says. Brown versus Board of Public Instruction said that applies to the schools. The Supreme Court had sent some cases back in other settings of the same principle, though. So you had a principle that was ingrained that you can't discriminate, government can't, on account of race. So it would have been very hard, in my view, for them to have written a decision in that case in which they say, well, the Supreme Court has not expressly overruled Plessy versus Ferguson, which said that separate but equal is okay. It would have been impossible. Well, and there's another thing about judging in cases like Judge Johnson has, and that's the integrity of the court. The integrity of what you do. I wore your moccasins for a couple of years as state trial judge, so I know, and then as a district judge, so I know what kinds of issues you have, especially in very hard cases. But the integrity of the court, really the independence of the judiciary. The independence of the judiciary is only, there's independence only so long as the public is willing to respect the courts. And the public respects the courts when they deal with litigants fairly and get to the controversy narrowly, decide only what's there, and then issue a judgment. So most of the public, hopefully encouraged by excellent reporting by the press, honest reporting, that's how the public views the courts. Basically, it's through the press. Otherwise, you get an impression from a neighbor had a case, and word of mouth sort of stuff. So that's the key to me in the independence of the judiciary is the way in which you go about deciding cases. The key being fairness before you ever get to the rule of decision. Everybody's been heard. And so that was permeating through everything that he did. I don't ever recall a case in which he reached out. There are a lot of people think Frank Johnson had some magic wand, and he just came down here in Montgomery and started raising all kind of hell. Because he was a strong guy, which he was, and he saw stuff that in his gut was wrong, so that's the last thing he would have ever done. And had he done that, his life may not have been, he may have died earlier. That's the true fact of the matter.
So a good example of that is the Gomillion case at the very beginning.
Yes.
Because everyone's gut would have said changing a square city to a 28-sided city, where mysteriously it was all then segregated, that was, your gut tells you that's wrong. And yet...
What happened was, so they got all the blacks outside, whites inside. There was a lawsuit brought by the government, federal, against the state of Alabama, the Board of Registrars, who registered people to vote, and the members of the board. Now, Alabama was very clever. It was brought under a Civil Rights Act of 1957. And that's when Frank Johnson had the case first. Well, the members of the Board of Registrars quit. So and then didn't do any good. They're not registrars anymore. They couldn't give you any relief. Well, neither could the board, because the board was just an empty piece of paper. So that left the state. But the problem with the Civil Rights Act of 1957 is it didn't allow the government to bring suit against the state of Alabama. So Frank Johnson's gut and what all the plaintiffs wanted would be, oh, strike it all down anyway. He said, no, I can't do that. I can't do that. The Civil Rights Act doesn't give me any power to do anything to the state of Alabama. Nothing. And that's the way he decided the case. And I imagine lots of blacks, a lot of plaintiffs were down, you know, it was so awful. The facts were so bad. So it went up. And our court, the Fifth Circuit, we affirmed because that statute didn't allow them to sue the state. And it went to the Supreme Court. What happened between the time our court affirmed and it got to the Supreme Court is Congress amended the 1957 statute in 1960 while the case is pending. So then the Supreme Court, in effect, sent it back, and it said, well, okay, the government can now sue the state. And so when it got back down and the government sues the state, and the hell with the Board of Registrars and these guys that ran off in the woods, he issued a decree, just like Supreme Court said you can, against the state, and then said to the state, you're going to have to register these people in accordance with the law. And he didn't say what I'm going to do if you don't, but it was obvious what he was going to do if you don't. He was going to have a show cause hearing on a motion for contempt and let them explain why they weren't doing what they're supposed to. So that's a perfect example where he decided something.
It's also a good example.
It was the gut said do it another way.
Right. It's also an example of how he, notwithstanding perhaps some people's desires, he respected the officials because the Justice Department asked for it to be taken away from the officials, the state officials, and he did something different.
Yeah, he respected that. He knew. He said this in a case. I said the same damn thing in a couple of cases. The Jacksonville school case. When you're suing the school board or the registrars or whatever, the last thing a federal judge wants to do is to take over their job. Then what happens? Yeah, I take it over now. So every Monday morning there's a show cause order for them to be held in contempt, and I got to hold a blooming hearing because I'm now the school board or I'm now the voting registrars. And some judges think that's pretty hot stuff. That's the last thing Frank Johnson would do, the very last thing. And not only that, it shows respect for even though the local people are violating the law, at least when you say, you do it, it's your job, I'm going to let you do it. I'm not going to tell you day by day how to do it, but you're going to comply with the law. You're breeding respect for local government, which had the responsibility anyway. And so...
You know, there's a quote that I'm trying to find because I think this illustrates two things that you said, both the respect for the local officials, but also making sure they understood that you meant it. In that opinion, he said, this court, for the time being, is going to permit the registration of applicants to be handled by state officials that are charged with the responsibility. This court, for the time being, declines the request of the United States that it appoint voting referees. Such a declination is made with the idea that the defendants can act fairly if the directions spelled out in this court's decree are followed in good faith.
And you know what their lawyers would say? I'm a registrar, so I say to my lawyer, what does for the time being mean? Can I foot drag this thing out? I don't have enough employees to register people. And if the lawyer wants himself to stay out of jail, He's got an ethical obligation. The time being is now. It means get with it. So, that was masterful.
And another, we talked about signaling, reading signals coming from the court, but I think Judge Johnson did a few signals of his own. In the Gamillion case, he said, this court has no authority. It was saying to the court, if you want me to do something different, you've got to spell it out. I'm relying on your precedent right now.
Yeah.
And of course they did spell it out. But the other interesting thing, and when I clerked for Judge Johnson, it was clear that courts existed not for attorneys, but for litigants to get answers to their questions. And if you didn't get the opinion circulated within a month of hearing, well, we never found out what happened to us. But he very definitely believed that orders ought to be entered timely. And when these cases came back to them, when the law was changed and he had the authority, he moved very promptly. He had the hearings. There was no delay on his part. I don't know. I know in some courts there is delay, but I think that was one thing that helped his...
when the Supreme Court said the state can now be sued, you got the public out there, the press is advising the public. If the judge takes a vacation, that has an effect, get back to independence of the judiciary, that has an effect on the public's perception of the judicial officer being willing to do what's got to be done with dispatch, not recklessly, but fairly. And that's the way it went.
Judge Tjoflat and I agreed that we would take questions in the middle of this presentation just because y'all might have some things that we might not have thought about. So if anyone has a question right now, we'll take it. Judge Tjoflat will.
Yeah.
Okay.
Judge, you talked about how you and Judge Johnson rely upon the media, the press,
Yes.
to help foster respect for the judiciary and the independence of the judiciary.
Yeah.
We seem today to be in a world where the press is more fractured.
The media.
We can't rely upon them as much. Any thoughts on how to...
It is a bad scene. And we're so fractured. It says, Judge Smith, you were appointed by this governor or this president or this damn thing, meaning you're biased. I mean, that's the way it is. And so you just have to. When I was on the district court, we had a courthouse reporter from the local newspaper. He was there all the time. And he'd go into chambers and he'd say, Judge, there's an order entered in this case that says X, Y, Z. What does that mean? What's behind it? Can you explain it? And it would come out in the press. That's what I'm not writing for the public through the press, just deciding the case. A good relationship, when I was on the state bench, we had the same thing. We had a guy named Hugh Green. Hugh Green was around there all the time. He knew everything that was going on. And that's what wound up in the newspaper. Notwithstanding that the world is so fractured that it's awful, and some people think that judges are nothing but a legislature that will grab you and put you in our corner. You still have to, in my view, have some kind of relationship with the press, some kind. And if you can't, you just do the best you can. But that is a problem.
So the world has changed a lot. I went back and looked at the Supreme Court at the time that Frank Johnson was appointed to the court. And the justices of that court, and this was right after the New Deal, and court packing, et cetera, But the judges of that time had such varied experience. And 3 of them had been senators. They had held elective office. They came from, a number of them were veterans, came from a very varied past. And I think the judiciary at that time, when you were appointed, could you speak to that?
Yeah, the judiciary has changed in that sense. When I came on the old Fifth Circuit, Elbert Tuttle from Atlanta was a general. At 57 years old, was in hand-to-hand combat in the Pacific, and was a great lawyer. Griffin Bell, they became Attorney General of the United States. John Minor Wisdom, all these judges came from varied backgrounds. Of course, most of them were raised in the 20s, well, before that even, and lived through the Depression. And the value system, that's what I saw when I came on. I was raised in 29, saw the same basic things. Frank Johnson also, he was born in 1918. And so most of these judges had been through a lot of life experiences. They talk about the Fifth Circuit having desegregated the South. The big four, they'd name 4 or 5 judges. I'm talking to the media. Well, these guys weren't afraid to do what the law required. Most of them had been shot at or whatever it is and lived through some tough times. If you looked at the biographies, take my court today or the Fifth Circuit, you wouldn't see anything approaching the life experiences of the judges. You may find somebody who taught in a law school, never practiced law, taught in a law school, they're now in the court. Or somebody was just a prosecutor and now is on the court. You don't, there's nothing in the bio that tells you they've lived through a lot of hell at one time or another. In other words, could take the heat in the kitchen. These were those days where you took the heat in the kitchen. The kitchen didn't get too hot. You could handle the heat. And life tenure, if you haven't got a lot of experience, of life experiences, life tenure doesn't do a whit. I've seen federal judges with life tenure melt. And I feel sorry for them. They melted because they'd never been in that kind of a pickle of any kind. So I say to you judges, you're involved in the community in lots of ways, in charitable endeavors and all kinds of things. And when you do those kinds of things, you learn how people think about things. And that helps you with because you're in a lonely job. You trial judges, you're not even, we sit together. You sit by yourself. And if you're on a multi-judge court, you could have 5 judges. You don't know what the other 4 judges is doing. You just by hearsay. So each job is lonely, and sometimes you get these god-awful cases, and you just draw back on what I would been talking about, what did in those days, due process, fair hearing, let everybody be heard, take the case under advisement, make a decision. Don't enter an injunction that's too damn broad, because the next thing that happens is, I'll give you an example. We had a judge in Fort Lauderdale, in that county, Broward County, we had a big foster care system set up by the state. We had social workers who would pick out foster parents and okay them. Then you have social workers who would go to the juvenile court and take custody. If the judge gave custody to the state, he got the kid. You got another set of social workers who decide where is this kid going to be put, what foster home. And then you got other workers who would supervise, come by the foster home. And they had down there a problem of sexual assaults in some of these with bullies in some of these foster homes. So what did they do? He filed an injunction in the Southern District of Florida down in Miami, and the judge took over the damn foster care system, basically. He said, all this big injunction. Tell you, here's what you do, here's what you do. Here. Well, every Monday morning there's 1 or 2 or 3 motions for order to show cause why they shouldn't be held in contempt. Well, it didn't take that judge about a month to realize he'd made a terrible mistake. and he slipped that case. I don't know. It wound up being a damages action under 1983, but that's what I mean. And that breeds disrespect for the law if the judge overreaches like that.
I'm going to mention, just because perhaps some of you don't know it, but Judge Johnson served in World War II. He was about to graduate from law school. They let him take his exams. I think when they drafted you, they didn't let you finish. No. But they let him take his exams. He went in. He was in the Army, and that usually means the infantry. He was wounded twice. First time they patched him up, sent him back. Second time he didn't have to go back to combat. He fought at Normandy as well. And those, when I clerked for him, which he had been on the bench 25 years, but when I clerked for him, he always said he didn't sweat about opinions. He did what was right. And
well, then you go home and sleep at night. Well, I mean, really. When you overreach and do all these damn things, you go home at night and you stay up all night. You better drink some whiskey or something or other to kill the memory.
Well, the judge did occasionally salute the Constitution.
Oh, should I tell that story?
Oh, why don't you?
Yeah. We always saluted the Constitution at 5 o'clock. Yep. If we were sitting in Atlanta, Judge Dabina's there in Atlanta, Judge Carnes is in Atlanta, we'd get together in one of the hotel rooms that night. He brings Baker Mark, I bring vodka and et cetera, and we're going to go to dinner together. We salute the Constitution. And that's a tradition. Well, anyway. This is about 1982 or 3, and Judge Dabina will remember. We went, about 20 people. He and I and Frank Johnson and some state court judges and a bunch of lawyers from this general area went in one of these boats, old boat, 40 feet, 50 feet long, that had a roof stilted up, and on top of the roof were some skiffs, 15 feet with a little kicker. And you'd put the skiffs down and run around. Anyway, so we met at Bayou Labatt, that's in Mississippi. And the Chandeleur Islands are like a half moon that go maybe 20, 25 miles out into the Gulf. And so it's a Sunday evening, and we all gather on this boat. And of course, we saluted the Constitution several times. And by the time the boat gets to the far end of the Chandeleur Islands, it's dark. We're in sleeping bags or whatever. So I get up in the morning, and the captain and a crewman, they get these skiffs down, they put them in the water. People are going to go out fishing. And Frank Johnson and I are going in a skiff, and we called him Uncle Willie sometimes. He called me Old Codger. He said, Old Codger, we're going to follow the captain and Curtis Caver, who was the clerk of the court here, because the captain knows where the fish are. So we followed Curtis and the captain in our skiff. And they're fishing, and we're out there, and there were some of these little islands about that high off the water, you know. And the trout are biting. And Curtis and the captain leave about 11:30 to go back to the boat because the captain's got to make arrangements for lunch. You got all these skiffs out there. And by this time, he says, we're going to fish tomorrow. Well, the tide rises, and all of a sudden we're 30 miles out or however far in the Gulf, and it is flat as this board, and the sun is straight up, and we don't know which way they went at all, or which way that boat is. And there are no waves or nothing. I said, old codger, I said, Uncle Willie, we better salute the Constitution. He said, you got it. So we saluted the Constitution, and we took off in one direction for about 10 minutes. Nothing. And they turned around and went that way. Nothing. We turned around and went that way. Nothing. Saluting the Constitution one more time. These little miniatures, you know. We came to a rusted steel shrimp boat trawler. All the gear was rusted. Now, you know what that means. That means it's a drug boat. Okay, and we pulled alongside, and he hollers, ahoy there, ahoy there. And some guy comes out of the cabin wiping his eyes, and he said, Frank said, where's the captain? He said, the captain's fishing. I said, Uncle Willie, we better get the hell out of here because he may go back in there and come out with a gun. So, whoop, he didn't know where the north lighthouse was at the top of the north end of the chandeliers, so we took off in another way. Well, we found the lighthouse, but we're about 20 miles or so from the boat at the far end of the chandelier, and we're down to almost no gas. So we decided to go about 20 yards off the shore down there. And when we get down to where the boat is, all these guys are out in skiffs looking for us, all over the damn place. We're disappeared. So he says, old codger, you got to haul this boat. We're out of gas. So I get out of the boat into the blooming sand, wrap the coil around, and walk to had some lunch and went fishing. Anyway, what great times. And that's part of the human man, the humanity. You know.
Well,
So, of course, there was a little tobacco chewing while that was going on, in between saluting the Constitution.
yes. Judge Johnson told me he started smoking when he was a young man because he was told it was good for him. He quit smoking when he was told it was bad for him, and he took up chewing tobacco by the time I cleared for him.
Oh, and he did one other thing. He was a great cabinet maker.
Yeah.
An incredible cabinet maker. And he and I built a grandfather clock in his garage. It took about 3 days. But he was super. In our court in Atlanta is a big cabinet where you go in to the clerk's office, in front of the clerk's office. He was a superb cabinet maker, and he learned how to do that by working in the WPA in the 30s when they're building privies. For here and there. You know what I mean by a privy, don't you?
Judge?
Yeah.
You must tell the story about the maple headboards on the fishing trip when we stayed at Bill's Fish Camp down there, where the room was $7 a night, and you and I roomed together, and Judge Johnson had the can of Lysol. He would come in and spray everything with Lysol.
Ruth was worried about him catching some kind of virus. So we're down in Swanee, Florida, which is ancient. The houses they're tin roof houses, and they're old, dilapidated. And we got this place where about 5 of us, 5 beds, and it's got maple headboards. And Ruth told him, and she gave him some Lysol to spray around to kill the bugs. So he sprayed the maple headboard. Well, you know what happened? The varnish came. And we sprayed it again and tried to wipe it clean. And then the next thing was we had to pray that the landlord, this was a fishing camp, I wouldn't care less. So, but anyway, so be it. What a treat it is to come here in this building. It's just an incredible treat to come here because it cranks up all kinds of memories. I swore in Judge Dabena in this building, and I swore in Judge Carnes in this building, and when I was chief judge of the circuit. A lot of things happened in this building. We dedicated the building to Frank Johnson. In the lobby downstairs is the plaque. And just, I love to sit in Montgomery, hold court about once a year. We ride circuit, Montgomery, Atlanta, Jacksonville, Florida, and Miami. But this is a choice place to do it. And what a delight it is to meet with state court judges. You're in the trench all the time, and your behavior is what establishes the integrity of the judiciary, really, day in and day out, because that's where divorce cases are heard and all kinds of cases that people are all hung up in, worried about, and it's their impression when they come away from your daily work that is what creates the image out there that the judiciary is really something in this country. And this is very important in this day in which, like in the Kavanaugh hearings, we have all these kind of crazy people doing crazy things about judges. What you're doing is you're healing the whole situation, in my judgment.
Judge Cobb.
Judge Tjoflat, you and I shared that when I was a trial judge, that my house was firebombed, and that was the same year that Judge Robert Vance was killed. In fact, it was 4 months later.
1989.
1989.
December.
December of 89, and mine was September of 89. And what we talk about independence of the judiciary, and lots of times we talk about it framed because of politics, right? Political losing election. But how would you discuss with the judges about those difficult cases where Judge Johnson and you, having been the senior judge when we lost one of our beloved federal judges because of a pipe bomb, what advice would you give?
About those kinds of settings? You just have a lonely job, that's all I can say. And your families are the best support you have, and your colleagues. That's the best I can say. What you're doing is very important. Sometimes the day in and day out gets a little drudgery, and you say, well, does it really matter what I'm doing? It means a hell of a lot, especially to some litigant who's never been in court before and before you that day.
Judge, when, I'm going to follow up on that question. When Judge Vance is, when he was killed, you were chief judge then, and you undertook all of the, I mean, it was up to you to try to make sure that the court was safe and...
colleague Robert Vance in Birmingham, one of the 12 judges on the court, was assassinated by a man who sent a pipe bomb through the mail. It was in a shoebox size with a pipe loaded with red dot powder and 10-penny finishing nails around it. And it was sent to him purportedly by a judge on the court who lived in Noonan, Georgia. And the assassin also sent a pipe bomb in a shoebox to our court, to the clerk of our court in Atlanta, same way, same day. Sent also a pipe bomb to the NACP office in Jacksonville, Florida, supposedly from a clergyman in Warner Robins, and sent a pipe bomb same way to a lawyer in Savannah who happened to be of counsel in the Savannah school desegregation case at one time. Judge Vance's bomb got there. They were all mailed on Friday. His bomb got to his house on Saturday. Helen Vance picked it up from the postman, took it and put it on the kitchen table, and said it came from Pete Morgan, that's the other judge. They used to send stuff back and forth. This is Saturday the 16th of December. And bomb opened the pipe bomb. The bomb was this way, and it literally cut him in two. The bomb that came to our court didn't get there till Monday morning. By that time, we knew about the mayhem on Saturday, and we had X-ray machines and everything else, and we caught that bomb. But we're unable to get the bomb intact. It blew in the bomb squad. The bomb that went to Savannah got there that Monday, and the guy opened it, and it chopped him up. The bomb that went to the NACP office in Jacksonville, as a woman on Monday was beginning to open the bomb, the package, but the phone rang and she had to leave. And of course, everything in the media, the next morning she called the FBI and they captured that bomb intact. But we thought, because appellate judges sit in groups of 3, we thought that 2 other judges besides Bob Vance were at risk because he decided a case sitting with 2 other judges. We would have no way of knowing except going back in time. And so we had the whole court locked down for 12 months. We sat nowhere except Atlanta. The Marshal Service took over a floor in the Ritz-Carlton, had 2 command posts. And so all of the judges and their law clerks, when we held court in Atlanta, we stayed at the Ritz. They took our automobiles. We were driven everywhere you had to go by marshals, including spouses and children that were at home, same way. But those are tragedies that happen. Hopefully not too often, but that's a risk of what we do.
You know, I think we have time to touch on, you were a member of the old Fifth Circuit.
Yeah.
The real old Fifth Circuit before it was expanded.
Yeah.
And then you added, I think, 11 judges in a year.
We had 15 judges, and Congress gave us 11 in 1979.
And that's when I clerked, and there were 26 when you went to en banc. It was kind of interesting.
You can't, 26 judges can't decide anything. I mean really. So we petitioned the Congress. We told the Congress for years, we had 15 judges. Don't give us another judge. If you're going to do something, split the 6 states, because half of the business was in Texas, Louisiana, and Mississippi, and half in Florida, Georgia, and Alabama, so it would be an easy thing to do. But they wouldn't do that. So they gave us 11 judges. And it was a mob. You can't decide. We would sit together, all 26. I told the chief judge when we hear an appeal with 26 on the bench, I said, we ought to go sit in the pews and put the lawyers on the bench. But so anyway, Congress did see in its wisdom split the circuit, and we became the 11th, and they retained the 5th. We had 12 judges, and they had 14, because 12 lived. We could.
I don't know.
Anyway, so that's how that happened.
Okay. Any good stories coming from that?
About the 26.
Oh, yeah.
Oh, my. You can't imagine. When we got to 26, it was in July and August of '79. And we always sat as a full court, the whole 15, in September, February, and June to rehear cases en banc, we call it. And so we decided that we wouldn't do that. We would meet in New Orleans, and we would start with the chief judge and go in seniority down the list. And everybody would say, what are we going to do with this mob? Well, 15 said, we got to split. We can't do justice with this mob. And of course, the new ones, they said, well, we think you can make it work. These are brand spanking new judges. They didn't. A couple of them have been judges before, but so anyway, so we tabled the motion to split the whole discussion for a year. And we sat on bunk with the 26th in February. We had 2 or 3 cases. We heard them on oral argument on Monday. It took us until Friday evening after dinner to decide those 3 cases. Having all 26 having a word, and it was like herding cats or something. And about 3 weeks later, the new 11, wrote the chief judge a note and said, we need to have a hearing on it. We need to take it off the table. And that's how the split started.
And it was interesting the way they did it. They split into 2 units for a year to try to get the cases segregated, and then went. But if you thought that it was interesting sitting at that en banc looking down, I can tell you as a clerk, it was really interesting looking up at 26 judges.
We have a question.
Okay.
What did she say?
The state of the judiciary, where do you see it heading?
What is the state of the judiciary?
And where is it heading?
Where is it heading? That's a good question. The state of the judiciary is that legislators in particular, federal and state, whatever, governors, presidents, whatever, all kinds of people, academics, the elite, want to use the judiciary to solve problems that they can't get the legislature themselves to solve, and the executive branch can't solve them without more. So we'll dump it on the judges. And the judges have got to resist that temptation, state and federal. When you have a statute or some ordinance or something or other before you that has got a bunch of holes in it, that's how legislators do. They enact things with holes, expecting judges to fill in the blanks. Instead of filling in the blanks and taking over their job, we have to say, you go back to the drawing board. It's your statute, it's your ordinance, it's your this, it's your that. And we're not going to entertain the case because we can't do it. Every state, I think, has a separation of powers doctrine. Well, when you fill in the holes and the blanks and do all those things, what you're doing is you're arrogating unto yourself the legislative branch's power. So that's this business of packing the Supreme Court, for example. That's nothing but we'll make the Supreme Court bigger so they can be our legislature and decide things we want the way we want, which is nonsense. Which would bring the judiciary into total disrespect. It might get some things solved, but in the solving, we would be denigrating ourselves. And it may be that's the same notion in the state courts. The federal judiciary, I'll speak about that than the states. The size of the federal judiciary, the number of trial judges we can have, is determined by the size of the Court of Appeals. If the Court of Appeals can't handle the cases because there are too many, and then creating more trial judges creates more uncertainty in the court. The bigger the Court of Appeals, the more uncertain the law is. When the law is unstable, that hurts every citizen in the country. It hurts people with regard to their civil rights. It hurts property owners. It hurts everybody. You wind up with watered down rights. So the federal judiciary can't get any bigger, in my view, without that problem. Well, the same thing is true in the states. You got a state Supreme, like Florida, we got a state Supreme Court, and we have 5 district courts of appeals. The first district court of appeals has 15 judges. The Supreme Court of Florida tries the best it can to resolve conflicts amongst the intermediate appellate courts. That's a hard thing to do. So what is the solution? The solution is we have to educate the public that we don't solve all of our problems in the courthouse. Not all of our problems in the court. It used to be, when I practiced law, we had on the letterhead, attorneys and counselors. You're counseling the client. The client wants to do something. The client wants to build a widget factory. The client wants to do this. The client wants to do that. And your job is to help the client do what the client wants to do within the parameters of the law. But what do we do nowadays? Especially when you got attorney's fees provided for by statute. File suit right away. It's to take domestic relations. File the blooming suit and get a temporary attorney's fees along with a support order, temporary, instead of trying to patch things up. In the domestic end, in my view, we've got to do state legislation in particular and some federal. We have to honor the families. We got a lot of laws out there that are contra to healthy families, and we should take that into account. But we've got to learn how to solve problems outside the courthouse. We have to learn that. And in this terribly divisive society we've got, that's hard to do. People won't listen to each other, but we have to start doing that. And the younger people have, and you judges, when you make speeches and when you go to high schools or wherever you go, to civic groups, you have to pound hard on, we got to begin to solve problems through conciliation ourselves with lawyers, but not going to court, because everybody loses in court. Everybody loses. You eat up, you've seen these cases. We see them all the time. They're up and down. There was a judgment for $500,000, but by the time it's up and down 3 or 4 times, there won't be anything. It's like you picked the carcass clean. There's nothing on the turkey. So we have to decide. We have to learn how to do that, and that is contra to what society is doing now. Everybody's against everybody else. We got to stop that. And I think judges are in a perfect position to drive the point home. Why? Because you're right in the middle. You're the middle. You're the ones that have to solve these problems. And the society needs to know some of these problems can't be solved. They can be solved, but at a hell of a price against the litigants. So that's where I see the judiciary. I don't see anything good unless we can reverse that aspect of the thing. Courts are scarce. I'm speaking in economic terms. They are scarce dispute resolution resources. Courts are. They're scarce. And they're scarce because there are only so many of them. And if we have too many, they can't get to, they won't do the job. It's like if out west, if water is scarce, what do? You try to preserve it the best you can so that everybody has some water. Well, courts are like that. They are scarce resources for resolving disputes. Neighborhoods can resolve disputes easier, yeah.
Do you have an opinion about the trend towards self-litigated parties, pro ses, massive increase in the rate of people who come to court without lawyers?
Yeah, there are a lot of pro ses. I assume that most pro ses have been to legal aid or something or other and have been turned down. That's my guess. You would know better than I. No, they haven't.
Are they coming based on resources from the internet, or?
Well, yeah, there's that part too. I kind of see that there's a kind of
That's part of this communication problem. I mean, that's part of the job that the judiciary as a whole has got to communicate to their citizens. There's a better way of doing it than the pro se litigation or going at each other's throats all the time.
Well, unless there's another question, I want to thank you, Judge Tjoflat. This has been a privilege to talk with you and to hear your wisdom, and you're welcome in Montgomery anytime.
I love it. It was fun. I knew it would be fun.
Yeah,
Well, good luck.
And you know, I should have said something about this. The judge said he was appointed to a state court position, but according to Wikipedia, when his term was up, he was unopposed for election.
Yeah. It was weird.